Triggs, welcome again. Would you like to make an opening statement before subjecting yourself to any questions?
Yes, Senator Macdonald, I would like to make an opening statement.
Fine. Yeah.
Well, thank you very much for the opportunity to speak to you. In recent weeks, questions have been raised about the decision by the Commission to conduct a national inquiry into the health and developmental impacts of prolonged immigration detention on children. I would like to take a few minutes of your time to respond to these questions by setting out the Commission's statutory functions and the work of the Commission in respect of these children in 2013 and 14, and by explaining why the inquiry was held. The report of the Commission's inquiry into the impact of immigration detention on children, the forgotten children, has now been tabled in Parliament and is available to the public. The inquiry took place from January 2013 to October 2014, covering the periods of both the former and current governments. The medical and other data in the report provide credible and objective evidence that mandatory, prolonged and often isolated and indefinite detention has a significantly damaging effect on children. The bipartisan nature of government responsibility for this damage is clear on any fair reading of this report. May I begin by wholeheartedly welcoming the release by the government of about 700 children over the last few months. We hope that our inquiry has played some role in encouraging this change in policy. However, on the latest figures available to the Commission, about 330 children remain in closed detention in Australia and Nauru. And while the numbers in Australia are declining, the numbers in Nauru appear to be increasing. In summary, the inquiry was called in response to mounting concern about the health impacts of prolonged detention on children and to the significant numbers that remained in detention. The Australian Human Rights Commission has been on record since mandatory detention was first introduced in 1992, reporting to Parliament that prolonged detention of children amounts to arbitrary detention under the International Covenant on Civil and Political Rights and on the Convention for the Protection of Children. This law is well settled. Arbitrary detention without charge or trial by our peers is contrary to the rule of law and to the international obligations to which Australia has agreed. The aim of the inquiry was not to revisit this settled law, but rather to conduct an in-depth assessment of the medical and developmental impacts on children of lengthy immigration detention. The Australian Human Rights Commission Act 1986 provides the Commission with functions to inquire into any act or practice that may be inconsistent with or contrary to any human right. A human right is defined by reference to certain human rights treaties to which Australia is a party, including the two treaties I've just mentioned. These treaties, however, have not been legislated as part of Australian law by Parliament. The consequence is that while the government of the day may act according to Australian laws, these actions may well be contrary to our international legal obligations. In the absence of national laws that apply international human rights in Australia, the Human Rights Commission provides a necessary, independent and respected check and balance on government to ensure that our democracy is a just one. Most of the work of the Commission and the Commissioners who've joined me here today attracts bipartisan support from government, whether it concerns discrimination on the basis of race, sex, sexual orientation, age or disability, social justice for Aboriginal and Torres Strait Islanders, or the rights of children. Some of our work, especially in relation to refugees, does not always command the support of government of the day. It's for this reason that the independence of the Commission is protected by statute, allowing us to continue our work without fear or favour. It's with that legal background that I'd like to turn to two issues that have been raised about the inquiry into the impacts of lengthy detention of children. The first concerns the programme of work on refugees in 2013 and 14. The Commission has worked tirelessly over the last decade, but especially in the last 3 years, reporting on the failure of respective governments of the time to comply with their international obligations. I'd like to table a document that summarises more than 180 pieces of work completed by the Commission on immigration detention over the last 5 years, including, of course, the most recent years. And it might be useful to begin, if I may, with a report of my predecessor, the Honourable Catherine Branson, who completed in July 2012 an inquiry into the age determination process for children held in detention. Following that inquiry, the Commission conducted a range of activities in 2013 in respect of the rising number of refugee children detained in Australia and offshore, a programme that's fully documented in our report. For example, we conducted monitoring visits to detention centres in mainland Australia and Christmas Island. Within 8 weeks of my appointment in July 2012, immediately on the tabling of the Catherine Hanson's report into age determination processes, I was at the Villa Detention Centre, and 4 weeks later I was on Christmas Island interviewing children and their families. The report of these visits was the first of 3 such reports in my first 15 months as President. The Commission has issued 36 reports to Parliament in relation to 89 complainants over the last 4 years in respect of immigration detention and asylum seekers, each of which must be assessed independently by the Commission. We've also researched and provided a report to Parliament in October 2013, the Snapshot Report, a sort of State of the Nation report with regard to the continued detention of detainees. We provided many submissions to parliamentary committees examining proposed changes to legislation and in particular to the Migration Act. We've intervened in a number of High Court cases relating to refugees and asylum seekers. I've regularly met and written to Ministers of Immigration raising concerns about children in detention centres in Curtin, Manus Island and Christmas Island, about the situation of unaccompanied minors and those of differing sexual orientation, and I've repeatedly urged the Government to ensure that the detention of children is a matter of last resort. The documents you have now received show that issues relating to children in detention were raised in every meeting that I had with the Minister or relevant Minister of the time. In summary, throughout 2012 and 2013, the Commission was fully committed to the monitoring and reporting on the conditions of hundreds of children in detention. Secondly, questions have been raised about the precise timing of the inquiry, and I shall try to be as clear as I can. The decision to hold an inquiry was one that evolved gradually through 2013 and reflected many factors. There was no one trigger, but a combination of many. But of overarching importance were the high numbers of children. I'm sorry?
Triggs, you can talk to us rather than, I mean, you keep looking at the media. You can.
I was momentarily distracted by the clicking of the cameras,
I'm sorry.
but I shall try my very best to look in the other direction.
Okay, thanks.
I'm sorry if it worries you that I looked at the cameras.
That's okay.
Of overarching importance were the high numbers of children held in detention, numbers that fluctuated considerably over the year. Other factors were the increasing periods of time for which the children were being held. The need to ensure the Commission had the necessary resources to conduct an inquiry, especially as we just completed an inquiry in 2012 and a full report to the Attorney in 2013, and in light of the forthcoming election, when information would not be available through the caretaker period. Finally, good governance of the Commission requires annual planning. The Commission confirmed its work plan for 2013-14 on the 26th of June 2013 that envisaged a 10-year review in 2014 of the situation of children in detention. That was to commence only once the snapshot report was completed and subject to available resources. I'd like to table now 2 graphs which detail evidence that informed the Commission's decision to hold an inquiry. These graphs show the following. Between the peak time in July 2013 and October 2013, the former government released about 750 children. In light of our continuing work throughout that period with regard to children, there was at that moment no immediate urgency to call the inquiry, even were the Commission in a position to do so. It soon became clear, however, that after October 2013, the numbers of children being released stagnated, so that 4 months later, by February 2014, about the same number of children remained in detention as at the election. Obviously, the period of time for which the children was being held was lengthening as each week and month went by. These evolving factors led to the decision by the Commission on the 12th of December that the long-planned 10-year review would be a full inquiry with powers to compel the production of evidence. The Attorney and the Department of Immigration were advised accordingly on the 22nd of January 2014. The documents we've given you confirm my earlier advice to the Senate Committee that I regularly discussed concerns about children in immigration detention with all Ministers of Immigration. I did not, however, specifically refer to the proposed review or inquiry with any minister in the former government, and the documents confirm that. And so, in conclusion, over the last 10 years, the Commission's extensive work for children in immigration detention documents beyond doubt the trauma and damage that's being inflicted on them. The report speaks for itself. Australians can now read it and make up their own minds about the consequences of Australia's detention policies for children. May I respectfully ask the members of the Senate to read the report, to consider the findings and to act on the recommendations we've made. The Commissioners and I will be very happy to answer any questions you have.
Thanks very much for that, Professor Triggs.